I'm still not sure why. I thought that the whole purpose of a special review scheme, especially one that puts review in an agency, is to consolidate rather than bifurcate review of agency action. And here, as the government pointed out, when it did want to bifurcation with temporary cease and desist orders, the Congress made an exception, sending that to the district courts. I think that really shows you that when Congress wants to send something else, it knows how to. That's what it did in the CSRA review scheme. So I don't, and like Elgin, I have a hard time thinking why the nature of the constitutional claim would deprive the parties or the district court of clear guidance that should go through the scheme.
So I think
I still don't understand, is there something special about structural constitutional claims? And I don't really know what they are, because for you it's easy, it's removal, okay? But your colleague, Mr. Clement, wants to go broader on what structural is, and I don't really see how you divide that out from just regular due process claims. But maybe you can give me a clearer definition than I've received so far in the case law or from Mr. Clement on what structural means to you.
Sure. So,
and give me some sort of special damage that you're suffering
sure.
under that definition.
So on structural constitutional claims, I'd point you to the court's decision in Carr versus Saul, in which it recognized the class of claims as structural constitutional claims and cited—
I'm sorry, which case?
Carr versus Saul dealt with the
Remind me of what it said.
In that case, the court held that you didn't have to exhaust appointments clause challenges before administrative agencies, that you could bring that bring that in Article 3 court. And because of the unique nature of structural constitutional claims, among other considerations, but in discussing structural constitutional claims, the court cited numerous cases of examples, including the Free Enterprise Fund case. In terms of why they're different, Your Honor, we are suffering by the mere fact of having to proceed before an unconstitutional agency decision maker inflicts what this court called a here and now injury that exists wholly apart from the ultimate outcome of that proceeding. And that's different from almost any other type of preliminary challenge you could imagine to that proceeding.
If there's a due process violation of any kind in a proceeding, whether it's a violation of a regulation or a violation of not enough notice or not enough clarity, those things routinely, certainly in court cases, we leave to the end. But I don't know why we should be permitting district court interference with the process that Congress has given to the agency to conclude that matter.
So I think this court has recognized that structural constitutional claims are different in terms of how they inflict injury that's separate and unique. And the other point I would say is, in order to get meaningful redress of that injury, you need an injunction that stops the proceedings, forcing you, that prevents you from having to undergo them again. And that's different from a case where even if you suffered a due process violation based on the particular application of a rule or a statute, you could get relief from that, getting relief from the order. That's not true with respect to this unique class of constitutional claims here.